I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today I am bringing you compilation number 120, and we will be in 3 different judges' courtrooms for this compilation. Before I give you the rundown on those judges, don't forget to like, share, comment, and subscribe. It is much appreciated. Also, chapters will be added to this compilation for your convenience, just in case you want to jump around, take it in bites, come back, start where you left off. However it is you want to do it, we got the chapters added just for you. Now, for number 120, the first judge courtroom that we will be in is Judge Kayla Wilcox out of the state of Washington. And this is also going to be a new proceeding. This proceeding just occurred a few days ago. So that will be Judge Kalo Wilcox out of the state of Washington. Second, we will be in the courtroom of Judge Stephanie Boyd out of the state of Texas. And last but not least, we will be in the courtroom of Judge Joe Lee, also out of the state of Washington. As always, it is a pleasure to bring you guys these compilations. We're going to keep them rolling. How fast we get to 200, we'll see. But for now, let's just deal with number 120 and jump on in.
Civil Department will give you that denial order. It has the verbiage in it that says that not here, there, and then use that and get things filed up there if you want to pursue it.
I already did file. They rejected everything. So.
Well, unfortunately, try again with the order from this court.
All right. Thank you.
All right, thanks. All right, now back to Ms. Wally. Sorry, sir, to confuse you. Your name?
You mind giving me just a minute here? I've just been rushed into here and I have not had access to any of the courts and any phone calls whatsoever. I just need about 10 more minutes if possible.
Okay, what's your name though?
Okay, I'm here by a special and a limited appearance as the man. And at this point in time, per the common law side of the court, I'd like to enter an order.
What do your friends call you?
Excuse me, do you mind letting me finish? I'd like to.
Well, I need to know who you are. I can't help you.
Okay.
Who do you think I think you are? Who do they put on documents that you don't agree with? What's that name?
As I said, I'm here by special and limited appearance, and in accordance to the common law side of this court,
so Ms. Gannam, did you have a chance to talk with the man I'm trying to figure out?
Yes, as the jail believes, this is Raymond of the family Paulo.
Excuse me, I told you not to interfere and you accepted that liability. As per FARA, Foreign Agent Registration Act, you do not have the right to represent me as a legal person because that would be a fraud upon the court.
Okay.
Per FARA,
Mr. Paulo or Ray or Raymond, how do you like me? How would you like me to refer to you, sir? I can't just say, hey, you. How would you like me to refer to you?
Capacity as an interested party.
Is that what your friends call you? Your family call you? What do they call you?
What part of it did you not hear?
I'm still looking for a name.
Okay, well, I'm not my name. I'm a man standing on the land as a Washingtonian American national, non-resident alien to the U.S. And I'm not doing any business whatsoever and or trade into the jurisdiction of the U.S. and or subcorporation. I have never been in the United States. That's the facts. And so per the common law, trespass is now being attempted at this point in time. And from the beginning, I want to address this in a particular manner in order to settle these differences so that there is no unlawful conversions of estate property.
Okay, I'm going to jump over to the prosecutor and ask him what they know. So, okay, Mr. Sharp,
okay.
Has this person been identified?
No, please, Your Honor.
Okay, so is Mr. Sharp, do you have a first and last name?
One person at a time, sir. Let me hear from the prosecutor and then I'll turn back.
Yes, Your Honor. Mr. Paulo's identity was confirmed when he was arrested for trespassing and searched.
Slow down, sir. I just need to hear from one person at a time. I will come back to you. So please keep your peace while I listen to the prosecutor. All right. I'm sorry. Go ahead.
Your Honor, a search incident to arrest uncovered a Washington State ID card that confirmed his identity as Mr. Paulo.
Raymond Paulo with a date of birth, June 25, 69.
That's correct.
Okay. All right. So,
A legal person or a dead entity or a corporation?
so sir, are you telling me you don't want an attorney to represent you or what?
Attorney, in fact, I wouldn't need any to represent me, especially under the 11th Amendment. This would be an unlawful proceedings due to the facts.
Well, all right. So you got a right to have a lawyer represent you because you're charged with a criminal offense by the city of Lacey.
My rights.
And do you want Ms. Ganem, who's an attorney here in Washington, to assist you today?
Excuse me, I said I needed 10 minutes and you were saying you're going to suggest something or another.
Well, I may give you 10 minutes, but we may see you tomorrow too. But I wonder, do you want an attorney to assist you?
Okay.
Do you want an attorney to assist you or not? I just need a yes or no there.
I'm hereby going to enter an order into the common law side of this court.
So I need a yes or no, sir. Do you want an attorney to assist you?
Exhaust my.
A yes or no answer, sir. Do you want an attorney to assist you? Can you answer yes or no to that? Do you want an attorney? Do you want an attorney?
I am an attorney, in fact, for the unincorporated state, and with all due respect, the U.S. and all of your administrative law is not providing me any services due to the facts is that I'm ordering a stay on the common law side of this court in order to address my
So you say you're an attorney. In fact, have you been allowed to practice law in the state of Washington by the Supreme Court of Washington?
No, I'm not a bar member. I'm not
okay.
Society. I'm a man.
All right. So do you want an attorney to help you?
I'm hereby entering an order on the common law side of this court in order to stay for these administrative hearings for me to exhaust all my administrative.
You got a few, I think you're a little confused and you got bad information. This is a criminal case, not an administrative hearing. It's a criminal case. You're charged with a crime called criminal trespass in the first degree. And it carries a maximum sentence of 364 days in jail and a $5,000 fine. And again, you have a right to have an attorney and a right to not testify against yourself if you go to trial or hearing. You have a right to be presumed innocent, and you cannot be found guilty unless the city of Lacey proves this against you to beyond a reasonable doubt, or if you pled guilty to it, that would be your choice. Again, you have the right to have an attorney assist you here. Anything? I'm still trying to get a question answered there. Do you want to answer that question or not?
Am I going to be able to answer without your interference? Because you keep cutting me off. That's not the sort of conduct that's necessary. It seems to be you're practicing law from the bench. I would appreciate it if you refrain from such and let me speak for myself as a man, not a legal person or a legal entity or a corporation which I've denied. And I'm going to show you the paper here on the affidavit. Affidavit, statement of truth. I, man, living soul, hereby deny corporate existence and do not occupy any corporate capacity and or status whatsoever. I further state the above statement of facts are true, correct, and not misleading, and swear to each under the penalties of perjury per 28 U.S.C. 1746C. And there's my signature, Raymond Van Paulo, December 22nd. All rights reserved, not a sunset, not pro time.
Okay, Raymond Paulo, we finally established that. All right, got it. Do you want an attorney to help you?
Excuse me, per the common law, you are now trespassing. That's a common law trespass. Please. Are you a bar member? You have a conflict of interest. I would imagine you need to recuse yourself if you want to operate on that side of the court.
Well, you got a lot of mistakes there you're citing, and I'm trying to help clear it up for you. So
opinions have nothing to do with me as a man because you don't have any jurisdiction. You don't have any authority.
What happens next, Mr. Paulo, who you say you are because you signed that document, it would be good for you to get that filed with the court at some point if you want us to review it more closely.
You're still interfering with my abilities and you're misrepresenting and making statements on my behalf. You do not have the authority. I'm revoking, rescinding all signatures, power of attorney, and terminating. And I'd like the prosecutor to provide proof of his certificate of authority to administrate any claims against the unincorporated sovereign estate. And if he fails to, then I will accept his bar card and your.
Mr. Paulo, I'm not doing anything on your behalf as an attorney. I'm the judge here.
Okay, well,
And we're trying to get through an arraignment, and I've told you what you're charged with and what the maximum possible sentence
I'm not a
is.
debtor.
We've gone through your rights, and some of those rights also are, if you were to go to motion or trial, you have the right to have the court order people to come testify on your behalf, and you have the right to question witnesses that may be brought by the city against you. So where we are is, I'm still trying to figure out if you want an attorney, and you haven't asked me to appoint an attorney, but I can do that if you'd like.
So you're not able to basically act in accordance to the canons. So at this point in time, by special appearance and limited manner, I'm entering an order by special deposits to the foreign courts in order to put a stay on the hearings in order for me to exhaust my administrative remedies.
Okay. So
I hereby order the court to vacation any liens on the account and release the real property and personal property. I believe it's standard forms 1991 if they're still in effect.
Yeah. So Ms. Ganem, anything you want to add here?
Nothing additional, Your Honor. I was not able to get much information.
No, I told you you're not to be
one person at a time, Mr. Paulo, please. Let me just hear from Ms. Ganem, and then I'll turn back to you.
I Raymond of the family Paulo. Do not unlawfully convert the estate name.
All right.
So an unlawful conversion. This is identity theft. Okay, so at this point in time, I'm going to read your rights. You have the right to remain silent. Anything you say or do to use in court of law. If you don't understand your rights, an attorney will be appointed to you. Do you understand your rights? All bar members and those present in this particular hearing and on the common law side in which I'm standing.
So I'm going to turn to the prosecuting attorney, Mr. Sharp. What's the recommendation here on release conditions?
Thank you, Your Honor.
I should make it clear probable cause was found the first.
I didn't get any discovery, so I don't know about those things. Those are all presumptions.
Well, city will just make a record that the city has grave reservations about Mr. Paulo being allowed to represent himself.
Objection. This is identity theft.
Mr. Paulo, stop interrupting and I'll get back to you. I'm going to hear from you next. So I suggest you listen and then you respond. Stop interrupting. We're going to have to. Okay, I will come back to you. I will be coming back to you. So listen and then respond. So first off, we got to listen. So Mr. Sharp.
Thank you, Your Honor. Again, the city has grave reservations it would like to express about Mr. Paulo being allowed to represent himself, and while he may have a right to do so, the statements he's made before the court today seem to suggest he either has multiple grave misunderstandings about the way the law works and the way the court proceeds, or is just unwilling to participate in the process in a functional way. Either way, it seems a grave injustice to not have a properly educated and trained attorney assisting him. However, I do recognize that he has that right should he choose to exercise it. City's requesting $250 bail on this case, law-abiding behavior. Did he not have any contact with the Peak Credit Union? Your Honor, the street address for that is
this in the United States?
Your Honor, that's 4-4s. 6th Avenue Southeast. Oh, excuse me. I'm sorry. I've got the wrong report for the address here. Pardon me.
Made a mistake.
4540. That's 4540 6th Avenue Southeast. City's bail request is based on concerns over Mr. Paulo's ability or likelihood to reappear under Rule 3.2. The statements that he's made before the court today suggest that he's not likely to respond to the court's orders, given that he's rejected the court's authority over this matter. City believes without some bail, he would be likely to fly or at least fail to appear for future hearings.
So, Ms. Ganem, you say you haven't had a chance to talk with Mr. Paolo, for lack of a better name that I can use here. And I'd like to, it's been difficult for us to talk, obviously, too.
On my common law side of the court, definitely, if you're going to unlawfully convert and it suggests that we're running in a different manner, well, then I'm not participating in bad faith, and with clean hands, I'm not participating in the unlawful conversions of the unincorporated as a state property,
So,
and that's
Ms.
land
Ganem,
included.
Yes.
You called down, or how did you, were you on the phone, or was he not willing to talk with you, or?
I attempted to speak on the phone, and he has made it clear to me that he does not want me to speak on his behalf at all.
Stand down. You're in violation of FARA, Foreign Agent.
So nobody's in violation of anything here. I'm just asking questions, sir.
Yes, Your Honor. I attempted to have a conversation with him, and he has not answered any of my questions that I asked him, and has made it clear that he does not want me to say one word on his behalf at this hearing.
Okay. And
Your Honor,
so, yep, Mr. Sharp.
Given the statements made before the court here this afternoon, the city feels obligated to, well, I'll defer to the court on this, but would suggest considering the issue of competency. The statements have been consistently nonsensical and seem to suggest that Mr. Paulo may have an inability to understand the court proceedings. Without further information, we can't rule out that he's able to proceed competently. City would again defer to the court, but perhaps an evaluation is in order.
So I'm not convinced at this stage. I'm convinced that Mr. Paulo doesn't agree with the proceedings and doesn't agree with the state of the law in Washington, and that's fine. Problem is, it's still happening the way he doesn't agree. It still is a fact. And so, Mr. Paulo, I'm being asked to have you post bond or in order to be released, and then set another hearing and have you back to court if you are out of custody, or have another hearing anyway if you're in custody. Do you have anything to say about this request from the city, and also that you don't go back to that 4540 6th Avenue Southeast? It's a credit union, did you say?
It's the Peak Credit Union.
Peak Credit Union. So you have anything to say on that? I think somebody muted you, so we're going to need the help of corrections there and Lacey to unmute you.
Me?
Ah, you're back. So do you have any response to what the city wants me to do on release conditions?
As a man or a legal person?
Whatever way you want to respond.
No, as the statement that he's made to a man or a legal person, because I'm not a corporation, as the affidavit, a statement of truth, has now been entered into the public record. And after reading,
how do you want to respond?
As bar members, you have a conflict of interest, especially a judge. If you have a bar card, I've accepted your bar card and your oath of office and the attorneys. And if the attorney is not willing to provide the certificate of authority to bring a claim against my own estate, well, the facts remain is that's actually a common law.
So, sir, how do you feel about me ordering you not to go back to that credit union, the Peak Credit Union?
I'm sorry, you're speaking to a man or are you speaking to somebody else?
To you.
A man?
You're a physical human being in the Nisqually jail. I'm talking to you.
A man, yes or no? Are you speaking to a man?
You look like a man to me.
Okay, well, I know what I look like, but I've asked you directly. Are you directing me to that question as a man? Not that I look like one, because I'm a man, I'm not a legal person, and I'm not a corporation.
Okay, to you, the man who's sitting in Nisqually jail.
Okay, and so
what do you say?
Is that identified as a legal person then?
What do you say?
I'm sorry, you're cutting out.
What would you like to tell me about what I should do about your custody status? Should I let you out? Should I not? Should I order you to stay away from Peak Credit Union? What do you have to say about that?
Well, I would like to be in I would like to request a the judge's chambers in order to protect my privacy?
No, this is a public hearing. We're going to do this in
Right, but I'd like
public.
to be
So
in
what's your
to have
response?
I believe it's called Star Chambers in order to protect my publicity and
So do you
in
have a
order to protect.
response to that question about release conditions or not?
Okay, I'm sorry. It's very echoey in here. So if you
Yeah.
keep cutting me off, you're frustrating me for no reason other than it fears you're interfering. So if you could just respond slower and not cut me off because you're agitating me. As an American with disabilities, and I've been deprived for now 8 days of a hearing. So beyond the 48 hours, I don't know why we're even listening to this because you failed to meet the mandatory obligations to bring any party to the courts, as you have fraudulently induced me to believe something when in fact fraud upon the court is evident and now part of the public record. So with that.
So Mr. Paolo, what we're doing here is I'm entering a plea of not guilty to this allegation of criminal trespass in the first degree. I'm not appointing an attorney, as you've told me that you want no one to help you. You can change your mind about that and we can appoint an attorney and keep that in mind. I'm going to order that you don't go back to that Peak Credit Union where this is alleged to have occurred at 4540 6th Avenue Southeast in Lacey. Don't go back there, subject, and don't violate the law otherwise. I don't see a history of failing to appear in court for the last 20 some years, so I'm not going to have you post any bond. But I'm going to give you a court date to be back and you're representing yourself unless you ask the court to appoint somebody or we think differently about that, but you've got to tell us if you want an attorney appointed. And what date?
Okay, the issue at hand that I hear is that you're saying representing myself. I am myself as an attorney in fact. So the fact of the matter is if you misrepresent and misidentify the things I'm stating, these unlawful conversions create a cause of action, and under the common law, this is a trespass. So with all due respect, I'm willing to entertain on the private side, the common law side, if you guys refrain from forcing me to be subject to these unreasonable circumstances in bad faith. I would not have anything to do with the county because I do not live in the United States. That being said, and the only place I've ever heard of is at the time which I went to the Lacey police in order to file a case against the party who wrote an $11,000 check. Her name is Sheila Connor. And I
think we're getting off track here. It's not about you anymore. So we're going to be back January 5th. You need to come to court. And if you don't, and there's no good reason, the court might issue a warrant for your arrest, but come to court. And if you want the court to appoint an attorney, we sure would do that. But stay away from Peak Credit Union, stay out of trouble, be back in district court January 5th. That's all for today.
Am I being
knock
released
on the door and they'll let you out.
Today. Can I confirm?
That's all for today. So long.
Excuse me?
So long. You can knock on the door there and they'll let you out and they'll release you from custody. We'll see you January 5th.
Okay, I want to continue.
I'm going to move on. Mr. Stashevsky, you've got a client in the corrections facility with you.
All right, the court, and I guess this is for one case. Court is calling 2024 CR 4295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Yeah, I'll wait for Arlene Gay is the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? Mm-hmm. All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have.
Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling, okay.
Yes.
The
next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and what and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling? All right, if there's something you don't understand, let me know, all right? And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right, so number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 U.S.C.S. 841. This court now under federal questioning under Title 28 U.S.C. 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing and to prosecute me, which is they're one by third party.
Okay.
And I'm not, I don't, third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that, I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand? All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points? Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay? So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mm-hmm.
My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel.
Mm-hmm.
Right, Mr. Beltran, that's not to be heard right now. Okay.
All right, and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand? And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled Court Constitutional Notice.
Mm-hmm.
And that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right, do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right, the first is new discovery of antitrust violation lies, fraud upon the court, elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the State Bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you.
Yes, sir.
All right, the next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says, objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding this collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell, there are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am. State,
has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No, Judge.
All right. Does that address that issue for you?
yes, ma'am.
All right, then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, Your Honor.
All right, does that address that issue?
Yes, Your Honor.
I think the other issues deal on the second page, deal with the state bar, and I think the courts address that.
Okay.
The other one is gross advertising negligence of the DA's office.
Okay.
And defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically, it is sort of a suit, but it's, again, the state of Texas versus whoever the defendant is. You understand?
Yes, Your Honor.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is that something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, Your Honor.
All right. All right, is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No, Your Honor.
All right, is there anything that you don't understand about the jury trial process? All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, Your Honor.
All right, so if you still want a jury trial, you're, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the jury trial, please, and Ms. Galloway, if you confer with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome.
Right, the next matter is State versus Isaiah Curvin, 24 TR 17. There's a name of Isaiah Curvin on the screen. Please turn on your monitor.
I'm here.
Mr. Curvin, is the headgear you're wearing a religious item?
It's a cap. I'm outside. It was snowing out here. I'm in Oklahoma City. I'll take it off in a second. That's why I got my jackets on. Yeah, it's kind of cold outside. No problem. Yeah.
Thank you. All right. This is your first appearance. we were scheduled for an earlier date. Mr. Curvin did not appear at that time. A 30-day suspension letter was ordered to be sent. Mr. Curvin apparently contacted the clerk's office following at some point in intervening and requested hearing. So we're here today for first appearance. Mr. Curvin, you are charged with driving without a valid driver's license or no DL. That is a Class B non-person misdemeanor. A B misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. Not saying that's what the penalty will be. It's just what the maximum available under Kansas law. You have the right to a trial if you are subject to a jail sentence, or if that's a possibility, then if you wish to have an attorney but could not afford one, you could apply to the court. If you met the financial guidelines, then I would appoint an attorney to represent you. However, if a person is not facing a jail sentence, then they're not entitled to court-appointed counsel. We'll take that up as go further. Additionally, at a trial, you would have the right to be presumed not guilty. The state would have the burden of proof of beyond a reasonable doubt. You would have the right to cross-examine the state's witnesses. You have the right to call witnesses on your own behalf and to utilize the court subpoena power to make sure they attend. Additionally, you would have the right to testify or not testify as you see fit. If you chose not to testify, that could not be used against you in determining if you're guilty or not guilty. Do you understand your rights, sir?
I do. Yes, sir.
In a moment, I'm going to ask how you wish to proceed in regards to a plea. Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Very well. Mr. Curvin, you looks like you're 33 years old. So absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then your plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing. I would hear from both parties in a pronounced sentence. If you plead no contest, that is then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
So on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of action in regard of the elements of my personal jurisdiction, the venue, and the nature cause of action until the prosecution has properly alleged them for me, and therefore I'm not able to enter a plea until then. I'd like to know if it's going to be if I'm going to be tried under common law, or is it going to be under maritime law?
Can you speak up a little bit? It's difficult to hear you.
I got my headphones on. Did you hear what I said, or just what part did you need to?
I heard part of what you said. So.
Okay. I was saying, for the record, I did not simply understand nature and cause of action brought against me with regards of the elements of our personal jurisdiction, and also the nature cause of action until the jurisdiction, the prosecution has let me know what they're going to try me underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is it maritime law. So I can know how to defend myself, and then I can enter my plea.
Have you filed a motion for discovery in this case?
I filed in my, I put a special appearance in affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I actually faxed the special appearance. Did you receive it?
There's a document that looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature and says respondent beneficiary of the named defendant in constitutional rights / benefits.
It should
Is
be
that
like
the document you're referring to?
Yeah, I think is it just only one they went through? Because there's like 4 pages, 4 or 5, a few pages that went through, not just one.
There's a 1-page document.
There's only one. It's supposed to be more. I faxed to more over there. It was supposed to be like 4 pages.
It's 1 page. Where it begins is at the top. It says the Supreme Court said in U.S. versus Mirsky.
Yeah, I have a copy right here with me. I think you're just referring to the last page, and I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And that was the special appearance.
All right. Are you entering a plea of guilty, not guilty, or no contest?
I cannot answer a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action brought up yesterday.
Well, I've explained what you're charged with.
Yes.
I'm going to put you down as a plea of not guilty and set this matter for trial. If you wish to
because I was my special appearance didn't make it. I need to resend it as well. How can I reset it so I can have a chance to resend my special appearance because it didn't make it into. I guess you only had the last copy of it. There's more pages that you didn't receive. I need to enter that in beforehand. How can I reset it so I can do that? I have time to do that. I can do it today, and we can reset it for this same time next week if that's okay with you.
I'm going to go ahead and set this for trial. You can, if you have pretrial motions that you'd like to address, they need to be properly filed.
Okay.
Sometimes if people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that correctly. So there's an advantage to having an attorney. But I'm going to set aside 2 hours for bench trial.
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial.
Have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. It'll give you an opportunity to place your written motion for request for jury trial. We will set that hearing for Sarah. Can you give us a date within 30 days?
How long would you like for the pretrial, sir?
Anytime is fine before the 17th.
Hour.
Next 1 hour. Okay.
Miss Gillette, on the 17th, do you have very much scheduled with Satterfield for your half day?
Can I do another day besides the 17th? I can't make that day. I have something on that day. Is there maybe the 15th or or maybe after the 17th, that's the one day I cannot make.
We could do the morning of May 1st at 9 a.m.
Okay.
So May 1st at 9 a.m. That will be in person at the Elk County Courthouse in Howard, Kansas. You'll need to appear at that time. You'll need to have your pretrial motions filed, including your request for a jury trial. At that time, if everything's in order, we'll set a trial. Counsel, anything further?
Not on Mr. Curvin, Judge.
Mr. Curvin, anything further today?
No, Judge.
Very well. With that, we are adjourned.
I'm not threatening you. Say one more word and that's 30 days. 30 days.